Powell, he's in custody. It's a bail review setting. He has a felony attached, and I spoke to DVD about the situation, and it is a little confusing because it appears when he was in felony court, the residence that he's supposed to stay away from is actually his mother's residence where he lives. The complaining witness is like a roommate.
Okay, let's pause for a second. Did you catch that? We're now looking at a situation where the complaining witness is technically living in the same house she's supposed to be protected from. Carly Powell had his bond amended to allow him to return home. But here's the kicker. The protective order was never updated. So legally he's not supposed to be there, even though a judge verbally allowed it. Messy. Absolutely. This is one of those moments where courtroom bureaucracy and real lives collide like a slow-motion car crash. Now here's the real question. Should outdated paperwork carry more weight than a judge's verbal approval?
That he let a gentleman and this gentleman's girlfriend move in with him. And so
in her house
with the mom, with the mom. And then the allegation is that the complaining witness stated that he, assaulted her on a different occasion. And then that's when the charges were filed. So
complaining and stated that Mr. Powell.
Yes, assaulted her.
Okay.
And then charges were filed and he was given bond conditions. And at that time, like January 31st, a MOEP was signed. Okay. And he had an ankle monitor. But the complaining witness then went to a rehab facility for crack addiction, I believe. And so when she was out of the house, he goes back to felony court. He goes back home. He goes back to felony court. The judge allowed him to amend the bond condition so he can go back to that residence.
Sure.
Yeah, that's when I spoke to DVD. But the problem was the MOEP was still in place when he went back to the house. So I think it's a violate bond condition and a MOEP. But since that time, I guess when he spoke to Judge Peebles, that he amended the bond conditions, removed the ankle monitor, and allowed him to go back home. In this court today, the violate the protective order is alleged to have occurred that the complaining witness went to the house where his mom lives to get her stuff because she was told she had to move out because her boyfriend now is in custody for a different offense. So she was asked to leave the residence. The mom didn't want her there. So she goes back to get her belongings. And that's when she encounters Mr. Powell's in the house because he's been living there with his mom. And so she does state, I think, in her, in the probable cause that he did not threaten her or he did not assault her, but here we are. I mean, it's a black letter law, right? Yeah. So obviously, I think everything's going to hinge on the felony case.
Yes, Judge, and we have notes as well saying that the felony court did remove that condition. It's just uncertain why they didn't amend it in the MOEP as well, but the bond condition was removed after it was found the complainant no longer resided at the
holding him at no bond too.
Right, so
I don't understand how.
And then that's what I'm saying. He does go back to court on the 19th.
No.
For the felony.
With our case, the problem is that he's still in communication with her, which is still a violation, right? You can go back to the house. You just can't. And I'm assuming the only reason he could go back to the house is because she's in rehab and she's gone. Right. But for her being in rehab, he still wouldn't be able to go there because I think the idea is that they don't have communication together.
And I think the date was the February.
And what I don't, the problem upstairs is they didn't try to anticipate if and when she would leave rehab to go back home, because if he's there, which he probably has nowhere else to go.
right. According to our case, she was there to get her belongings, and that's whenever they came into contact with one another.
So ours is a good case then.
Yes, technically, because it's based on the MOEP that wasn't amended. So
No,
because that's
no, but they still are having contact.
Yes,
That's the problem.
Just as
Not the fact that he's
just as pled.
Well, he lives there. She came over to get her clothes because she was kicked out. It's his mom's house of 40 years.
Right.
Yeah.
Right.
And then she came,
And his mom is a complaining witness.
no,
Who's a complaining witness?
Complaining witness.
he moved
a
in
roommate.
basically to crackheads to the house. And it's a guy and the girlfriend. And then the girlfriend had to leave. And then the boyfriend of that girlfriend, it's not him. So basically he moves in two buddies, two friends.
Right. I get that. So it says here,
And the woman is the girlfriend of the,
one guy.
yeah, one
So
guy.
that's Miss Scott.
Yes, Judge.
Yes,
So that's Miss Scott's not.
not his
not-
mom.
not his
It's
mom.
not his mom.
Good.
So Miss Scott goes there to get her clothes.
Either, I don't know, I can't tell from the pleadings and what I've read, if it was before she was in rehab, after she was in rehab, or during rehab, when she goes back over there to get her stuff, because somebody, it indicates that someone told her she could no longer live there.
So it says here, did violate said order by intentionally and knowingly going to or near a place specifically described in the order to a residence of a protected individual, namely this address, right? I mean, if you're telling me that it was amended to where he could go there, I'm gonna find no probable cause.
We understand because the bond conditions were
Right.
amended in the felony.
You want to take a look just to make sure? Because it will affect an upstairs case.
Absolutely.
Powell.
And Judge, what we have, and just to be clear, the bond conditions
This is where the courtroom chess game really begins. The defense is arguing intent and timing, while the court is focused on technical violations. It's a legal gray area. The protective order was still active when the contact happened, even if the conditions were set to change the very next day. So the question is, was Powell actually violating the law or just caught in a procedural lag? You can almost feel the frustration building on both sides. And if you're wondering, yes,
were
In place.
amended.
Yeah.
The MOA was not amended, and that's what this media is based on. Just to make sure that the facts are.
And then according
There's
to,
two.
Was that an
different-
oversight on their part upstairs?
it appears
We
so.
don't know.
It may, probably was.
There's no note either way.
But
The vote was even
the
addressed.
bond conditions were amended for him to be able to go back to this.
To that same residence, Your Honor, yes.
And they removed his ankle monitor as well, so there was no exclusionary zone anymore.
And here's the rub though, they're holding him at no bond upstairs and then now for another 2 more days.
But the bond is removed. So,
I'm gonna find no PC. I mean, I can't,
This might be one I need to kind of go talk upstairs about.
do you want to email them real quick and see?
So
I mean, we haven't,
the DVD prosecutor did come down, and basically he was saying, you know, obviously it all depends on the felony, but he also indicated that the MOAP was still in place when the alleged.
Yes, Your Honor.
every right to be there because they amended the condition for him to be able to go back.
But I think they're saying the offense occurred before the amendment was made.
That's a different story then.
Yes, Your Honor. And so
Say that they amended the condition.
sorry, Your Honor, the other thing is this is a,
February 14th, and this office date
Oh.
is.
So see, what happened is when he went to the location, he got a bond violation. And so he appeared in felony court after that, and they amended it.
But he's still nevertheless,
Right.
Your Honor, before, I just asked for before
I'm not
a
going to.
decision.
Because this is the date, but it's the date before the conditions were modified. He still is going there when he's not supposed to be there. Right, okay.
But I was asked if he would reduce his bond.
It's at $500.
I know, can you reduce it to 100?
Let's do this. I don't know yet, because obviously he's still doing whatever he wants to do. And I have concerns, you know. Why don't we set this for the 20th, which is the day after felony court? Let's see what happens over there. And if they give him a PR bond and if they're okay with releasing him, then,
Your Honor, this is a DVD case as well, and so I'll have the DVD prosecutor.
Okay. yes.
Okay,
So
so we're gonna roll it to the
I
20th. All
would say, yeah, Thursday's the 20th so that we can,
Sounds good.
you know.
right, thank you.
I mean, if it was after, I'd find no problem because all that. No,
All right, thank you.
here. Are you ready? That's okay.
Mr. Matthews. It's a bond violation.
What's the last name?
Leonard. We wrote them from Friday. Yeah.
Come up, Mr. Leonard. As of 3/4/25, you failed to get a portable device. When did you get it?
I got it, this is the second one. I had to take, my first one because it wasn't registering just like this one's doing.
So, Your Honor, the long of it all is initially he had an order for an interlock. Doesn't have a car. This case happened. The date of the incident is like years ago. There was an accident. It was a 2B because he was hospitalized in the accident. There was a blood draw, determined that he was over the limit or whatever. So he comes to court and he's ordered to get an interlock, doesn't have a car, tells them he doesn't have a car. There's a bond violation filed.
First one is because he doesn't have a car, so he just decides not to get a device, right?
No, Your Honor, I believe he was telling him, I don't have a car. I mean, in all fairness, I don't believe he knows that he's supposed to then say, hey, can we do the portable or something like that? I don't believe that I don't believe he understands that. I mean, now obviously he does because I think maybe about a week or so later, he was ordered to get the portable device. He went and got a portable device. I just there were some issues with the portable device, and that's where this issue is coming in. He was supposed to get it by the 4th. It didn't come in until the 6th of March. And so he's gotten it. I've talked with the pretrial. She said there hasn't been any positive blows on it, but he's still saying that there's, it seems like it's not recording right or something like that.
So let's do this. So I'm just going to put a monitor on your ankle so I know that there are no issues. You know, I'll pay for it, but I'm going to put a scram monitor on your ankle so I know that there are no issues. Mr. Leonard, you must charge this thing on a daily basis. If you don't, if the battery dies,
Yes.
so will your bond. I don't want any more excuses. If you ever have an issue, you have a lawyer, will go to bat for you, but you can't just not do things because of what you want to do. There are orders in place and you must follow them, and that's it. Any more issues, we're going to have problems. You understand, Mr. Leonard? Okay. All right, we'll continue supervision.
Thank you, Your Honor.
Thank you, sir.
Right this way.
Judge, I've got an off-docket matter asking the court to set bond on a case, please.
Hold on. What's your cause number?
It's going to be Jaden Bolding. His cause number is 255-4634, 255-4634.
Okay, give me a second. Let me make sure everybody
Yes, sir.
gets it. You got it? Yes. No. 255-4634.
255-4634. Yes, sir.
34. No, 4634.
Okay.
Okay, you want to bring your client?
Yes, sir.
I'm sorry, what was that case number?
255-4634. It's an off-docket arraignment.
We need a PSR on that one.
Yeah. Good morning, sir. Give me one second. Did you hear that?
Yes, I got it, but I haven't done the PSR.
Take it down. All right, good morning, Mr. Balding.
Good morning, Your Honor.
Mr. Balding, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 7th, 2025, in Harris County, Texas, officers were dispatched to a mental health call and met with the witness and the complainant, who are the stepfather and mother of the defendant. The witness stated that the defendant suffered from an undiagnosed mental illness, which caused him to get triggered. The defendant was triggered by clothes lying on the bed and started to argue. The defendant grabbed a pair of scissors, which the complainant took from him before the defendant struck the complainant several times, causing pain. I'm sorry?
Struck who?
The complainant.
I know.
Who is stepfather, Your Honor?
The stepfather.
All right, Mr. Balding, I'm going to find that there's sufficient probable cause to go forward with your case. I am now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Lawson as a protected individual. You cannot commit family violence or an assault against this person. commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior. You cannot be in possession of a weapon. This usually comes with a residential restriction.
This judge is laying it down, no fluff, no excuses. It's part tough love, part TED Talk, and 100% real. A blunt reminder, your choices in court ripple far beyond the docket. Life's great with money, awful without it. Brutal maybe, but sometimes truth hits hard for a reason. What do you think? Do we need more judges like this, or less?
Figure, are they here?
They're not, but the state has
Your Honor,
conferred.
We have spoke with them and the complainant does want the defendant back at the residence.
I will take off the residential restriction. How old are you, sir?
I'm 27.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. And I'm telling you now that I'm going to test you for marijuana. If I find that you're using, it's not going to go well for you. Do you understand me?
Yes, sir.
I promise you, you're going to get tested. If I find that you're using, I will revoke your bond, put you in jail, no more PR bonds. I'm going to give you a PR bond today so that you don't go to jail. But if I find that you become a danger to my community, I will do everything in my power to protect every single person. I don't care what your excuse is. I don't care what you're going through. If there are issues, now is the time for you to take care of them. I hope that this is enough of a wake-up call that I don't have to put you in custody, because we have enough people in there now as it is. What do you do with yourself?
Yes, sir.
Are you in school? What do you do?
I'm planning on going back to college, sir. But I cut hair and I produce and I engineer music, sir.
Okay.
Let's work at
You
HEB.
graduate from high
Oh,
school?
and I work at HEB. Sorry, HEB is like my job, but it's in career.
High school. Did you finish high school?
Yes, sir. I graduated.
It's time for you now to also start thinking of the future. You know, the more education you get, the more money you're going to make in life. And I'm going to tell you, this life is so great if you have money, and it's so terribly awful when you don't. I promise you, the farther you go, the more knowledge you get, because knowledge is power. This is what you're going to get. This is not good. Now you have a lawyer. Have you signed on yet?
I will today, Judge.
I need you to sign on. I have attorney of records in the tower. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you've got to stay in touch with him, and he'll tell you if and when you have to come back. You're going to get tested. Don't use. You understand?
So
Okay. Guys, bond, any recommendation?
We would ask for maybe a $500 surety bond, not anything
Do you have
significant.
any priors?
Yes,
no priors.
no priors, Your Honor. And due to the mental health concern of the case, we wouldn't.
Surety bond's going to do what?
I spoke to the DVD prosecutor as well, and that's what he conveyed.
Well, I'm going to give you a PR bond. I'll set your bond at $100.
thank you, Your Honor.
Just make me proud. That's all I'm asking you to do, man.
Sir.
So what we're going to do now is I'm going to have you go sign a reset with Victoria. We'll have you take a seat while we generate all the paperwork. You will meet with Felicia for your bond conditions, and after that, you're free to go.
Very good.
Thank you, Judge.
So can you file no threatening, harassing, and no weapons, please?
Yes, sir.
What's the case?
Mr. Munoz Puente, you are charged with driving while intoxicated. You are facing up to 6 months in jail and/or a $2,000 fine.
$2 de multa.
You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. On July 4th, 2019, the officer observed a white Ford Mustang pull out of a Citgo gas station parking lot onto the 200 block of East Little York Road. The officer observed the Mustang failed to drive in a designated lane, driving over the striped white line in between lanes 1 and 2 multiple times while other vehicles were on the roadway. The defendant was unable to control its speed and accelerated and decelerated multiple times. A traffic stop was initiated. The defendant was observed to have red glossy eyes, slurred speech, and swaying while he was standing. The officer also observed a strong odor of an alcoholic beverage. The defendant admitted to drinking 5 beers, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. 2 spilled beers were found in the vehicle, and a search warrant was drawn and executed for the blood.
Why is this case 2,083 days old?
Just so speaking to him in 2019, he was arrested and there was an ICE detainer that was hit. He was picked up by immigration. He said when he was in the immigration court, they told him he could sign a waiver.
Voluntary departure?
Yeah, voluntary departure. That's what he did.
Mr. Munoz pointed, you want to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medications. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond and I'm going to put you in jail. I don't know what your immigration status is now. You now know what happens when you go to jail. They will possibly deport you. And I'm going to tell you, if you come back and you don't come back with the proper documentation, it could be 5 years minimum in federal custody on an illegal reentry charge. So when you do things the right way, good things happen. When you don't, there's serious consequences. If I find that you violate any of these conditions, I will put you in jail. Do you understand? Run his license, see if he has a valid license plate.
There's no license on file, Your Honor.
You are not allowed to drive. That is my most important position in this area now. If I find that you drive, I don't care what you, I can have a contempt hearing. You can be facing an additional 6 months jail and $500 fine. I will have you sign with me now an affidavit. This is a promise that you're going to make to me that you're not going to drive. I don't care what is going on in your life. If you don't have a license, a Texas license, and liability insurance in your name, you are not allowed to drive. You run his NCICC as a priority to the eyes, please.
Yes, Judge, I'll run it.
Your case number? It's 226-7399.
Your Honor, it appears based on the NCIC, there's a pending DWI out of Dallas County as well.
That's correct, Judge. He does have another open DWI in Dallas County. I believe he picked it up before this case. But it was a warrant for both of them, which was picked up for, I think they bond for both of these cases. So before he was deported, he had picked up both those DWIs.
Did he get a PR bond in this case? Munoz pointed out.
GOB, but it was First row, that's your and then he posted a
I'm going to put an ankle monitor on you, and I'm now giving you a code 7 to 7. If I find that you're out past 7 p.m., I will do everything in my power to protect the community at all costs. Do you understand?
Yes.
Unacceptable. Counsel, were you going to say something? If I find that you test positive for anything, and I don't care what it is, if you try to come here and try to tell me that it's mouthwash, it's a tequila lollipop, it's hair dye, it's mustache ointment, I will literally, if I find that you are driving a car, holy moly, I will absolutely lose it. Do you understand?
¿Lo entiende?
Don't dare
te atrevas
get near a
a
car.
acercarte a un automóvil.
So 7 to 7 curfew,
Después de 7 horas en su trabajo.
scram monitor, no alcohol, no drugs. Is all discovery in?
Yes, Judge, everything did.
Okay, so council, I'm gonna give you a 30-day setting. At that point, you gotta come back and let us know what you want to do. And then you have 30 days to go through all the discovery with your lawyer. And you come back at that time, I'm gonna either set your case for trial
Su caso
or
de
you will
juicio.
accept the plea bargain for the agreement. But at 2,000, and I know that the issues may have happened, but with another DWI open, it's time to do something about it. Okay, all right.
Thank you, Judge.
See you soon.
Se va a-
So when was the first time we tested him?
I believe February the 13th. I'm sorry, not the 13th. It was 2 weeks ago.
2 weeks ago. I have a note from the 10th saying that he tested positive for THC. We were just awaiting to see confirmation from the lab.
Because he was,
Confirmation is not come back.
When did we first test him, Fleischer?
Judge, 1 second, please. For Diego?
When was the first, we ordered him not to use when he first got here, correct? This case has been on docket for 64 days and you've continued to use. I've ordered you not to use. You just tested positive. You first came here 64 days ago. I ordered you not to use and you tested positive yesterday?
Sorry, Judge, it's loading.
Take your time.
I have positive on January 17th and then a positive on 3/10.
he was, I know, I understand the test, but my client's very comfortable with me and he was quite confused as to how the results came up positive because
I can tell you why. Okay, I'm revoking your bond. You're going into custody. It goes with you. I told you. So here's what we'll do. We can give it a couple days. I'll admonish him. Let him out. And clean out. If he cleans, great. If he doesn't,
he goes back in. Can a couple days be like Wednesday?
I'm okay with Thursday.
Okay.
Yeah, for sure.
And for Baptiste, I had filed a motion to withdraw in your queue.
Is he on land?
Huh? No, he's not on docket. But he doesn't have an attorney, so I don't know if the court wants to appoint. I'm just like,
I don't see him in the docket today.
oh, he's not. I'm just.
No. So we got to get him on the
Oh, it's
docket.
on the docket. And then
Right. I don't just grant because I've done it, granted, and the defendant gets here. Where's my lawyer? I just gave him
Got
money.
it. Okay, that makes sense.
So
On docket,
hey,
okay.
whatever you want, then we can do.
All right, thank you.
Ms. Wilson, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated for 18 months. As part of this agreement, you will do a DWI education class. Is it a true first state? You will do a true first. You will do a DWI education class. You will do, I guess there's no victim impact panel. You will do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. Random urinalysis, no drugs, no alcohol, guardian interlock, 20 hours of community service, and a $100 one-time donation to the Houston Food Bank. Is this how you understand this plea bargain agreement? You need to understand that you're here on a bond violation today because you failed to appear for a drug test. If you do the same thing while you're on probation, I will issue a warrant for your arrest. And we're going to have a hearing as to whether you're going to be doing 180 days in jail. You have to do stuff on time and you can't skip. I don't care what's going on in your life. If there's a choice between probation and something else, what is the choice that you have to make? Right. Because if you don't, you could be facing a lot of time in jail, and then you're not going to have your dog, you're not going to have your work, you're not going to have Cleophas. It doesn't matter. Probation is for a reason, and when you don't do probation, there are serious consequences. We issue warrants, put people in jail, bring them out in orange, and we have a hearing to determine whether you violated. And if you do, by testing positive, not doing your stuff on time, testing positive, you're looking at a ton of time. The other thing that you need to realize is that this DWI will be going on your record, and it's going to be there forever. You ever get pulled over in a car and an officer comes to you and they smell alcohol and they run your record and they see that you have a DWI, it's probably not going to go well for you. From now on, you're also facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no changing this. This is what you want to do. How do you plead to the offense, man? Guilty or not guilty?
Guilty.
I'll find you guilty. Do you know what happened on the ALR hearing? Can you run a license, please, Alex? What I'm trying to allude to is that I don't know what has happened with your license. I'm not going to suspend your license, but it's very possible that it got suspended through the administrative hearing versus DPS. If it did, your license and it is suspended, you're not allowed to drive, and that will also be a condition of your probation.
There's a current ALR suspension, Your Honor.
So your license is currently under suspension. You cannot drive. If you drove here, you can't drive home. It's suspended. Do you understand? So get the license back. Do you have children, ma'am?
No.
Okay. All right. Good luck to you.
Thank you.
Thank you.
Thank you, Your Honor.
All right. Coming up.